And now it is time for another installment in our thankfully very infrequent series, The Rachel Maddow Show Melodramatic Reenactment. First, the setting, the Ninth Circuit Federal Court of Appeals in San Francisco. The occasion, a case involving the alleged transport and torture of 5 terrorism suspects who were picked up as part of the CIA's extraordinary rendition program. The context here, the Bush administration's Justice Department getting the case dismissed last year using one of Mr. Bush's favorite tactics, claiming state secrets. They made the argument that even talking about this case in court, even with sensitive information excluded, would jeopardize national security. Whew. Good thing there's a new president in office, right? With a new Department of Justice in place for when those 5 prisoners appeal that dismissal, right? Right? Because there's no way the Obama administration would repeat the blanket state secrecy invocation, right? Right? Let's take a look at what was actually said by the lawyer and a judge in the San Francisco courtroom yesterday. We now join the hearing, already fake in progress.
May it please the court, I'm Douglas Letter from the United States Department of Justice, which has intervened in this case to urge affirmance.
When was the district court decision?
About a year ago, February.
About a year ago? Yeah. Is there anything material that has happened since that decision in terms of historical stage that has any bearing here?
No, Your Honor. No.
The change in administration has no bearing?
No, Your Honor.
The government's position is the same?
Exactly, Your Honor. The positions that I'm arguing have been thoroughly vetted with the appropriate officials within the new administration, and these are the authorized positions.
So you represent that you are conveying the views of the present Justice Department?
Exactly, Your Honor. Absolutely. Absolutely.
That scene is probably the closest we will ever get to seeing a federal judge, or at least a fake federal judge, doing a spit take. Like most people who were conscious during the last election cycle, Judge Schroeder probably assumed that the person who spent the better part of 2 years campaigning against Bush-era secrecy and Bush-era detention, interrogation, and torture policies, the man who is now President Barack Obama, would not go use the exact same state secrets defense that the Bush administration used as a blanket shield from accountability. A defense that means the government can do whatever it wants. It can break the law. It can avoid accountability by hiding behind state secrets. This provision intended to protect individual classified documents, but ballooned and mass-produced by the Bush administration to get entire cases preemptively dismissed. Did that really just happen like we think it did? Or did Kent and I make it seem way worse than it really was? Joining us now is Ben Weisner, the ACLU attorney who argued on behalf of the 5 plaintiffs and against the Obama Justice Department, and who will hopefully forgive me and Kent for acting out that hearing like idiots. Mr. Weisner, it's nice to meet you. Thank you for coming in.
Thanks for having me, and thank you also for not having somebody play me in that reenactment. I appreciate it.
We thought about it.
Yeah.
Then we realized you were going to be here in person. You might be mad. Let's understand the context. Who are your 5 clients, and why did you take this case?
These are 5 foreign citizens who were abducted off the streets of various countries, who had their clothes sliced off by CIA black renditions teams. These are people dressed like ninjas head to toe, who were chained to the floors of airplanes, dressed in diapers, and flown to dungeons literally around the world. Some of these were CIA black sites that were operated by our government. Some of them were prisons in countries like Egypt and Morocco that are absolutely notorious for their torture. And these flights were facilitated and organized by a private corporation that we sued in this lawsuit. This isn't the first time that we've tried to bring the administration into court on behalf of rendition victims. We brought a lawsuit earlier on behalf of an innocent German citizen named Khalid al-Masri that was similarly thrown out on these bogus state secrets grounds. We were hoping on Monday to have a different kind of experience with the new administration, but as you saw and as you reenacted, this is just a kinder and gentler version of Trust Us.
I know that the arguments in this case, the briefs had been fully prepared by the time that the Obama administration walked in the door here. All that was left to them was to do the oral arguments here. But Did Obama really just take this and run with it? Did they have another option here? Couldn't they even just have asked for more time to come up with a different plan?
That would have been the obvious thing for them to do. Remember, this is a motion to dismiss filed by the Bush administration. The basis for this motion to dismiss our lawsuit was a declaration filed by Michael Hayden, the current head of the CIA, for maybe a few more days. I don't know how much longer. And that declaration says that the CIA's detention and interrogation program is one of the most vital tools in our war against the terrorists. That if we let this case go forward, it will reveal classified interrogation techniques that will train our enemies in how to resist it. But on January 22nd, the actual president of the United States essentially ended that program. He banned those techniques. He closed the CIA prisons. He said that from now on we're going to comply with our treaties that prevent transfer of prisoners to countries that exercise torture. And so the question was, what is the Justice Department doing defending a declaration like that? Why are they standing in the way of accountability? And I do want to say here that there is no moral equivalence between the two administrations. You know, we have the benefit no longer to have our country run by war criminals. And it is terribly significant that the administration ended so-called enhanced interrogations, is shutting down Guantanamo, ended the extraordinary rendition program. Where we differ from them is on another critical issue, and that's the question of accountability. Yes. And I think that this administration would prefer to sweep the last 7 years under the rug and move on and get along. The problem is not a single torture victim, and there are hundreds, has yet had his day in court. And you did a segment on prosecution. I understand that's a controversial issue. The other side of the coin is civil liability. And if torture victims aren't going to be able to go into court at all, and bear in mind, if these victims can't go into court, I don't know which victims will be able to go into court, then really you'll have an immunity regime for the perpetrators, for the violators, and it'll be impossible really to enforce the prohibitions that are in those executive orders and in our laws.
This is really important stuff. Ben Weisner, attorney with the ACLU National Security Project, who argued for these 5 plaintiffs in yesterday's hearing. I hope that we helped get the word out about this. It seems incredibly important to me. Thank you for working on the case. Thanks for joining us.
Thanks for having me.
What you proposed, I read your speech at Georgetown yesterday. You said you're not looking for vengeance or to prosecute, but to look into a number of things, a truth commission, and we put those, the Iraq war intelligence that led to the war, the firings of the U.S. attorneys, the treatment and torture of terror suspects, and of course the warrantless wiretapping. Why do that? There's one Republican, Congressman Lamar Smith, who said this is an effort to just unjustly malign people in the Bush administration. Your response?
No, it's not. It's to make sure that we don't repeat the mistakes of the past. Everybody said, well, let's turn the page. I say, before you turn the page, read the page you're on. This is a, we did this once before with the Church Committee, just about the time I first came to the Senate. We found the abuses, the spying on people whose only sin was to protest the war in Vietnam, the wiretapping of people in the news media and so forth. I want to make, and once that was discovered, at least for years afterward, it wasn't done again. Now we find some of these same things being done. I want to make it public. I'm a former prosecutor. I know it'd be a lot easier to say, let's just go prosecute. That could take 15 years. I want to find out today what happened, who did what, and that way to make sure we don't make the same mistake. Not the Obama administration, not the next administration. Because if we continue to make these kind of mistakes, all our freedoms as Americans suffer.
Senator, there are no doubt a number of people who agree with you that there should be an investigation to look what went wrong. As you know, the president was asked about this in your proposal last night. Let's listen.
My view is also that nobody is above the law, and if there are clear instances of wrongdoing, that people should be prosecuted just like any ordinary citizen. But that, generally speaking, I'm more interested in looking forward than I am in looking backwards. So I will take a look at Senator Leahy's proposal, but my general orientation is to say let's get it right moving forward.
Senator, I don't have to tell you that was somewhat of a lukewarm support from the president. He says we should be looking forward. So will you change? Are you going to drop your idea to investigate the Bush administration?
Of course I'm not going to drop my idea. I know the president very well. He's a dear friend. I will sit down and talk about it. He is, right now, his message is, as it should be, on the economic stimulus plan. I've already begun discussions with the White House, and I will sit down and talk to the president about this. I think a strong case can be made for finding out what's going to happen. Otherwise, he's going to be plagued by this as we go on. They've already got to look into the secret memos in the Gonzales Attorney General in the Justice Department, the so-called Office of Legal Counsel secret memos. Those are going to be reviewed by the Obama administration. Those are going to be made available to the appropriate committees of Congress to find out where the law was misstated, where illegalities were condoned by the past administration. So a number of these things are going to come out anyway. What I'd like to do is get it out and get it done with.
All right, Senator, we'll be watching. Thanks so much for joining us.
Good to be with you. Thank you.